All right, so now we're on to the legal system, and in particular, we've already gone over a lot of the stuff related to case law, but that mostly relates to amendments and the Bill of Rights and how case law kind of interacts and the legal system interacts with those various laws, judicial review, and that kind of stuff. This whole unit is about the nuts and bolts of the legal system itself, the actual process. So this is all about the step-by-step civil and criminal aspect of basically what a court case is and what it looks like in the real world. All right, so first thing we got to talk about is civil case procedure. This is conflicts between individuals or between entities. This is civil. This is not criminal. No one's going to jail over this. No one's losing their life, liberty, or property over this in theory. The idea behind civil cases is just to settle conflicts between people. This is contract law, torts, things like assault, like simple assault and battery can sometimes be in civil, so like there's like a little bit of overlap there. So let's say I punched somebody in the face. Well, obviously that's an assault and battery at the criminal level. Well, there's also a civil crime of assault and battery, which basically the person is just trying to get money back for any damage I caused to them. So civil side of things, you're always talking about money. Criminal, you're talking about prosecution followed by possible incarceration or loss of life or liberty. So in a civil case, the plaintiff files a complaint. So a plaintiff is basically the person who's bringing the lawsuit. It names the defendant, it gives the reasons for the lawsuit, and asks the court to award damages or take some other action. So sometimes the court might be saying, the defendant might be wanting somebody to just complete a contract. So let's say somebody enters into a contract to buy a house, and then the seller backs out. Well, under North Carolina law, if they back out, you can seek what's called specific performance by the seller. If you're the plaintiff, you can sue the seller and say, hey, make him sell me this house. He had a contract, and the court can give that as a remedy. No, money's changing hands, so you're not talking about awarding of damages. It's more like injunctive relief. You're forcing somebody to do something with a court order. But you need to know this. A plaintiff is the person who files the lawsuit through a complaint. All right, next, the court sends a summons. It's a document that lists the charges to the defendant. So in the criminal context, there's also a defendant, but that's the only place where there's any similarity. So basically, it's a document, usually it's delivered by certified mail or by sheriff, and they just go out, lets them know, hey, you're being sued, show up on this date in court, and we can start talking about stuff and get it done. And here's the cool thing. If the defendant chooses not to go to court, then the plaintiff automatically wins. All right. The defendant then files a written answer admitting or denying the plaintiff's claims. And some of these claims inside of a complaint can be many, many pages long with many, many elements. So the defendant has to go through there with an attorney on each thing and say admit, deny, or not enough information. Admitting it means it's not a fact in contest, and I admit usually it's things like your name, where you live, how long you live there, that kind of stuff. If you owned a business, those basic things that are easily proven, those are usually admitted. But things regarding liability, who is at fault, that kind of stuff, that is always denied typically. And if they do answer and they say there's not enough information we can answer at this time, that counts as a denial. And anything that's denied then becomes an issue at trial. Your complaint plus your answer is what's called the pleadings. It's just a fun fact to know. All right, after you've started the lawsuit and the pleadings have been entered, you enter into discovery. In the civil context, there are no secrets. Basically, both parties are given all the information, and there's two reasons for this. One, it makes the whole thing fair. Second, it encourages settlement, so it encourages you not to go to trial, because if you know what the other side has at their disposal and you know if they have a good case, you're more inclined to settle your case. If everybody's keeping secrets, both sides think they got the ace in the hole, and they're both going to want to go to trial thinking they're going to win. But if you make all the parties know what's really happening with everybody, they tend to be more willing to settle. This is where attorneys exchange information about the case. They take depositions, which is basically just interviewing people under oath, answering various questions. And this is probably the most expensive part of a civil trial. When you're talking about pharmacy cases, security exchange cases, antitrust cases, these things can be gigantic, where you just have attorneys in giant buildings, top to bottom, all day long, just clicking on documents, millions and millions of documents to say if they're about the lawsuit or not. And it can take millions and millions of dollars to get through discovery. It's one of the reasons why settling cases often happens, because the cost of discovery is so incredibly high. All right, typically the case can be settled out of court. The defendant is offered a lump sum payment. Sometimes they're offered an annuity just to kind of protect the defendant. Most suits are resolved this way to avoid the time and expense and the risk of trial. So the time, obviously, these trials can last years. The expense is things like discovery, and the risk of trial is if you're in front of a jury, they might just not like the person who's talking, and they might find against you, even if you technically are in the right as far as the evidence is concerned. So you can't always trust juries. Or, if you can't settle, the attorney and plaintiff argue the case in court at trial. So this is the expensive part. And it's risky. You never know what a jury is going to do. Oftentimes, these cases are tried by a judge simply because they're going to be more inclined to be educated enough to know what's going on in some of these more complex litigations. The burden of proof is on the plaintiff, and we call the burden of proof in the civil context the preponderance of the evidence. You win a civil case by proving your case 50% plus one featherweight, which is basically as long as you're over 50%, you win. That's the standard. It's basically majority is on your side, then you win. The court then gives a verdict, which is not guilty or not guilty. It's typically liable or not liable, or if the people in the parties are seeking some kind of specific relief, they can give an injunction or injunctive relief, which is basically a court order telling one party or the other to not do something or forcing them to do something. Now, this verdict can be appealed, and we've already gone over the appeals process with the various state and federal courts, and it works just like in the criminal context. They appeal up, and then the verdicts are handed back down. You can have it remanded, reversed, or affirmed in that same basic process. So if you need to review that, head on back to the old videos about the various process of appeal at the federal and state level. All right, on to criminal case procedure. A lot of this is similar, but a lot of it is different. All this stuff before we get in the courtroom, very, very different. So the first thing that happens is an arrest. This is when the police arrest and quote-unquote book them. And they photograph, fingerprint, and the suspect is usually Mirandized before questioning. So remember the Miranda warning. You have, in order to basically question somebody who's in your custody, you have to give them their Miranda warning, which talks about your right to remain silent. You can get an attorney appointed to you if you can't afford one, all that fun stuff. Then you go to a preliminary hearing. This is where the suspect appeals before a municipal court judge or a magistrate, depending on what district you're in. Usually North Carolina, you're in front of a district court judge. And bail is determined. The judge then sends the case to a grand jury, or possibly to a judge. And we'll talk about that in just a second. Indictment. All right, so an indictment is essentially a grand jury, which is a group of 15 or so citizens who are appointed for a long period of time to sit and hear evidence. They hear evidence from the prosecutor and only the prosecutor. All the grand jury decides is if there's enough evidence to go to trial. They don't decide guilt or innocence. They don't decide liability. They don't decide if the guy did it or not. They don't answer questions of law. All they do is look at what one side presented, the prosecutor, and say, hey, is there enough based on this to say that they can go to trial? Now, once this is done, they issue a formal indictment and charge the suspect with a crime. This can also be done by a judge at what's called a probable cause hearing. It's the same process, but instead of a grand jury, it's a judge saying, is there probable cause that a crime was committed here? Same exact standard. Is there enough evidence? Is there probable cause? Can we go forward in trial? Is there any chance that we're going to get to a verdict that is beyond a reasonable doubt? And then you get to arraignment. This is where the defendant pleads guilty or not guilty, or accepts plea bargain. Most criminal cases are handled here. Like when you get to arraignment and they plead guilty, it's usually part of a plea bargain. Now the other option is to say not guilty, and then they set a date for trial. And they can be continued and they can be changed around. Lots of times the prosecution want to delay the trial. Other times the defense might want to delay the trial. They might want to delay it because they want to make sure they get a nice judge they like in there. Various reasons why a trial might get delayed. All right, now we're at trial. Both sides make opening statements. The district attorney who represents the people of the city where the crime was committed prosecutes the defendant. So if you hurt someone in Nash County and get arrested, you'll be tried in a Nash County court. Now, if you hurt somebody in Edgecombe County, you're going to be tried in the Edgecombe County court. And that gets a little tough when you get to that little county line split by the railroad tracks and you don't really know which part you're in sometimes. And it does become a bit of an issue. Now, the burden of proof is on the prosecution. Just like the burden of proof is on the plaintiff brings the case against the defendant. The prosecution brings the case against the defendant. So the burden is always on the party bringing the action, whether it's criminal or civil. In this case, however, it's not preponderance of the evidence. It's not 50% or a majority. It's beyond a reasonable doubt. Now, preponderance is easy because it's 50% plus some tiny percentage. That equals a win. Beyond a reasonable doubt, there's no percentage attached to it. It's basically what the jury thinks or the judge thinks if they're acting as a jury. What is beyond a reasonable doubt? That the accused is guilty. Reasonable doubt puts it in the mind of the jury what's reasonable to that juror. So when you get engaged in these trials, it's very important to know what the jury member's opinion of reasonable doubt is. All right, now at trial, a defense attorney can be hired or appointed by the court to defend the accused. So by this point, the defendant has an attorney. So they've either been appointed or hired at this point. Both sides present witnesses and testimony and may cross-examine witnesses from the opposing side. Now, here's the kicker. Remember, the burden of proof is on the prosecution. There are many cases, many times, where the defense doesn't even put on a witness. All the witnesses and all the evidence is from the prosecution because, remember, the prosecutor has to prove their case. The defense attorney doesn't have to prove their client's innocent or not guilty. They don't have to do anything technically. Sometimes the state's case might be so bad that all the defense attorney has to do is just poke holes in their witness and their evidence, and then put on no evidence and go to the jury and let things go. Now, typically, you're going to see experts come out for major crimes, major trials from the defense as well. So there is back and forth. But there are many cases, especially in smaller crimes, where the defense attorney is not going to put on a single witness. All they're going to do is just spend all their time poking holes in the opposing side's witnesses and their evidence. Because the burden of proof is on the prosecutor. They have to put on evidence to prove beyond a reasonable doubt. The defense attorney's job is to make sure that the prosecutor does their job and puts on enough evidence. The defense attorney pokes holes into it, basically tries to get to that point, well, now there's reasonable doubt because this person made this mistake or there's a hole in this evidence. But that doesn't mean they have to actually put on any evidence at themselves at all. All right, closing arguments are then made. The jury hears all the evidence of the case and deliberates to determine a verdict. So this can take days sometimes. Jury deliberations can be very nerve-wracking just because you're sitting there. It can take minutes. It can take days. It all depends on the size of the case, how controversial a case is, how well the evidence works. There's so many factors, but they can be short or very, very long deliberations. And in North Carolina, the verdict must be unanimous. So that means that all 12 people have to say guilty and or all 12 people have to say not guilty to get to a verdict. Now, if that doesn't happen, if a jury can't reach unanimity, meaning all 12 agree, they declare a mistrial, and the DA has to start all over again. The district attorney has to start a whole new trial to convict again. For a DA, this is considered a loss. When you have to have a mistrial after an entire months-long trial sometimes, that's considered a loss because you're talking about losing tons of money. It's all tax-funded, so you're talking about hurting taxpayers. It doesn't look good when the DA can't prove their case. That's why DAs are so incredibly protective of their cases and make sure the ones they put up are kind of slam dunks. Now, the other option, the defendant can be found not guilty by the jury and goes free. Defendant may not be retried for the same crime because the Fifth Amendment protects you from trouble double jeopardy. Blah. So hard to talk right now. Now, that doesn't mean, let's say you've killed somebody in North Carolina, but you kidnapped them. You took them from Virginia, drove across state lines, killed them in North Carolina. You're charged North Carolina for murder, but you're found not guilty. Well, the federal crime of kidnapping across state lines, well, that can be brought in federal court. So now they're going to bring you in at the federal level for the murder charge. There's two different statutes. I can't be retried for the murder at the state level, but I can have another trial for the different federal statute, remember federalism, at the federal national court level. So that's not double jeopardy. It's two separate statutes on the book being tried separately. And finally, if the jury finds the defendant guilty, as in a unanimous vote, all saying guilty, the judge and jury determine sentencing. The jury must make this. If the jury must make the decision, sentencing hearings are often held so the victims may address the jury. Usually, the jury only has a advisory component here. So let's say it's burglary. The jury might say, we believe you should go easy on him because he only did it because he was on drugs and he was trying to feed his habit. He didn't hurt anybody. There was no weapons involved. And then the judge can say, all right, I kind of agree with you. I'm going to go with a lighter sentence. Or they can say, no, that's stupid, jury. You don't get to say this, and I'm going to put you in jail for as long as I can. The only real exception to that is death penalty cases. Judges do not impose the death penalty. Juries do. All death penalty trials have two separate portions. You have the portion that's actually convicting the person of the capital crime, in our state it would be murder, and then you have a separate trial to determine whether or not you're going to have the death penalty imposed, and that's where you get witnesses coming out of the woodwork saying he was a sociopath, he killed little kittens when he was a kid, whatever, anything they can to try to get the guy with a needle in his arm. But for the most part, you're talking about the jury acting as an advisor. The only exception would be capital cases where they're the ones actually choosing whether or not to take somebody's life at the state's doing. But just know that juries impose the death penalty. Judges do not.